The ACC files a complaint against Clemson University in North Carolina. The ACC lawsuits are always in the news, so we're back on the Big Mountain to keep you updated. Hey, welcome back to the Mountain. I am JY. This is my good friend Steve. Steve, just a day after Clemson files their declaratory action in Pickens County, South Carolina, the ACC filed a complaint against Clemson University in, of course, Mecklenburg County, North Carolina. And just as a side note, the same judge, Judge Bledsoe, as we talked about in our first episode here, is going to hear both the FSU cases and is also going to be hearing this case as well. So this was a 42-page filing that had a whole bunch of exhibits, and so the entire filing was 133 pages, Steve. I read through all of this. I didn't read all the attachments because it was stuff we've already seen from the FSU filing. They lay out a lot of groundwork, and I'm going to just go over some of that on a glance. We covered a lot of this almost ad nauseum with the FSU lawsuits and filings. So if you've been on this channel for a while, you've heard us speak to a lot of that. I'm not going to go over that a ton. My focus here is really going to be for the Clemson specific points and items that may be new to us here on the Big Mountain that we haven't really covered before. And there are a few towards the end of this filing that are very specific to Clemson. Some of that's what you've been hearing in the headlines. The ACC starts out stating that this case involves the integrity of contracts. In agreeing to the grant of right contract, Clemson has granted their broadcasting rights to the conference through 2036. By taking action against the ACC, Clemson has breached its agreement to not take any action or permit any action to be taken by others that would affect the validity and enforcement of the grant of rights. Because of the Clemson action, the ACC now seeks 6 claims of relief, and very similar to what they filed against FSU. I'm going to say them here because I think they are important. Number 1, a declaration that the withdrawal penalty is valid and enforceable. Number 2, a declaration that Clemson has granted its rights through the grant of rights to the ACC, and this is exclusive and irrevocable. Item number 3, a declaration that Clemson is equitably stopped from attacking the grant of rights validity. Item number 4, a declaration that Clemson owes a fiduciary duty to the ACC. Item number 5, damages for this breach of the grant of rights. And item number 6, damage for this breach of good faith and fair dealing. They get into jurisdiction and venue, as Clemson did in their filing. Of course, they disagree on all of this, but the ACC states that Clemson has waived sovereign immunity in this case under the laws of the state of South Carolina. The ACC states that Clemson is subject to jurisdiction in North Carolina in matters involving the ACC, and that this court can exercise personal jurisdiction over Clemson. Also, the contracts at issue here are North Carolina contracts. Further, the ACC references the Farmer versus Troy case from 2022, same case that they discussed in the FSU lawsuit regarding those claims, and that this case falls under the Uniform Unincorporated Nonprofit Association Act. As a member of the conference, Clemson was given the right to sue and be sued in North Carolina. As for venue, the ACC states that this matter involves a dispute over a North Carolina contract, which are a form of intellectual property. The amount in dispute that is subject to this complaint exceeds $5 million. The next 20 pages here are then histories and details of the grant of rights, the media agreements. We've already gone over a ton of that stuff. Not going to regurgitate that here again, but there are some areas here that I do want to highlight as they're new to the ACC's case. Regarding the withdrawal penalty and alternate performance, the ACC indicates that their media consultant assessed lost revenue from a member withdrawing ranging from $6 to $18 million a year, depending on the identity of that member. So different members have different media values. And that was from back in 2012. And we talked about this originally with the FSU case, but I think it's really important to bring it up here again because it's kind of getting into this argument of liquidated damages. They really aren't supported by anything. They're purely punitive. That's what you heard from Clemson. That's what you hear a lot. And this is going to be the defense of the ACC saying, no, this is backed up by facts. Over the life of the 12-year agreement, then, that could mean $72 to $200 million of the loss of media rights. And again, this was from back in 2012. Another area that was brought up several times, some of which was redacted, has to do with warranties. And there were some redactions in this. I mean, you didn't see hardly any redactions, or if any redactions in the FSU filing from both sides. Now, in this case, there are some items being redacted again from both sides. The grant of rights warranty is listed, and I'm going to paraphrase this for now. It states that each member acknowledges that they are granting the rights for the entire term of the agreement, regardless of whether the member institution withdraws from the conference during the term or ceases participation. Warranties and representations surrounding the multimedia agreements between the conference and ESPN were basically completely redacted. You couldn't see it. The public can't see it. We probably, well, I don't know if we will or won't. For now, we're not going to see it. There's two areas that are very much Clemson specific here, Steve. I want to get into them next, but I want to give you a chance to chime in on anything.
Yeah, I mean, like you said, there's not a lot of differences. We talked about another episode. This is kind of a more refined version of the FSU case.
Right.
Clemson kept their case a little more narrow. Their allegations against the ACC a little more narrow. Now, Clemson had a chance to let Florida State go first and see kind of what worked, what the response was. So they got to refine their suit a little bit more. But at the same time, the ACC got that same benefit. You know, they've been through this with Florida State, the back and forth. So they were probably able to refine their responses, you know, in the same manner. You know, try and make things a little bit more targeted, a little bit more specific. They were ready for what Clemson was going to say, and they had some things prepared. And I don't know if you're going to cover this in the next section. I will just say, as far as jurisdiction and all that, I mean, the ACC is consistent that they feel like this should be in North Carolina, because that is where the conference is held, and they're using specific cases for nonprofits and whatever. I'll just say that I think that all of the schools and Clemson, similar to Florida State, well, Clemson is a public land grant university, so there's some differences with Florida State, but I'm sure they are going to continue to argue that the jurisdiction should be in South Carolina because they are a public university in South Carolina. They are operating, they are playing games, they're inviting teams. The teams are coming and playing games there. They're a public university that's executing a contract and performing a contract in the state of South Carolina because that's where they're operating, that's where they're performing. So it's going to be interesting, the back and forth on this. Very similar to the Florida State case, though.
For sure, yeah. And we're going to get an answer to that. You know, we did a breaking news episode on the venue jurisdiction piece for FSU, and hope, we're going to have an answer to that, and it'll, I would think, play a little bit into what's going to happen here as well, possibly.
Yeah, and what I think is really interesting, we talked about the possibility of the North Carolina judge and the state of Florida judge coming up with two different answers.
Yes.
They may disagree, and we could potentially have those two cases moving forward at the same time. That could happen here too.
Yep.
The South Carolina, they may disagree. The North Carolina judge may say something, and so we possibly at this point could have three different cases being played out in three different states.
And I'm just going to summarize three things quick, and then I'm going to get into some more of the detail that the ACC put in here, specifically regarding Clemson and some of the discussions that had been ongoing. But if you remember, Clemson has three parts to their action. One had to do with the scope of the grant of rights. The warranties that you can read here that are in the grant of rights are clear that that they're granting their rights for the entire term of the agreement, regardless of if they leave. So again, I know what people are going to say, a contract can be broken, yada, 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 but they're answering the question, at least what was the warranty within the grant of rights. They also are answering some of the question about the enforceability and validity of the withdrawal penalties, which is what the second item that Clemson brought up. And they're saying, hey, these aren't just punitive made-up numbers. These are actually based on facts and media value of this. Now, it's interesting that they give these facts about where these numbers come from, but what they're actually using in their constitutions based on their operating budget that really doesn't have anything to do with the media values of these. It's their support of the number, but it's apples and oranges. They're looking at completely two different things here. So
trying to connect two dots there to get but I don't know how that's going
to get to the same answer, really. At least in their minds, the same answer. So the other one has to do with the fiduciary duty, which the ACC is saying, nope, you broke it. Right, they're saying, hey, we didn't break this. We didn't try to break it. We're just looking for answers on these things. And the ACC says, no, you just broke it because you're questioning the grant of rights. I find that I don't understand that one. But anyway,
well, and that will lead. I think that will lead to more arguments of, can you have a contract that says, is that even valid to have a contract that says, if you feel like someone's not performing this contract, you're not allowed to sue. You're not allowed to say anything. You're not allowed to sue.
Yeah.
Is that even enforceable? Like,
that part just seems weird on both sides. Like I just don't get that piece to it. But anyway, let's get into these other two areas. So one piece of their filing, it's entitled "Clemson Seeks Unequal Revenue Distribution," and they state, the ACC points out that Texas and Oklahoma's date of withdrawal with the Big 12 coincided with the termination of the grant of rights for the Big 12. Thus, they were free at that point to market their media rights. Neither of these schools sued the Big 12 or sought to breach their grant of rights. The same occurred with USC and UCLA leaving the Pac-12. Now, did things get a little messy there? They did, but not to the level of they're trying to break the grant of rights, right? In response to these ongoings, in May of 2023, the ACC endorsed the concept of unequal revenue distributions. This would give a larger share of the postseason revenues to members that actually generated those revenues. This was the first time in the 70-year history that members agreed to unequal revenue distribution. The ACC continues and concludes that despite this willingness to implement a new distribution model to reward success, Clemson wants more. That's their conclusion. The other one, and the one that I think some people have heard if you've been following any of the headlines here, this one's entitled, "While Engaging in Discussions with the Conference, Clemson Prepares to Breach the Grant of Rights." They state, the ACC, following the filings of the FSU lawsuits, Clemson indicated a desire to work with the conference regarding its membership and requested assurances of confidentiality and protection that the ACC would not file a lawsuit against them. The ACC agreed as they looked to seek a business solution rather than resort to litigation. While these assurances were being documented, Clemson filed a complaint in South Carolina without provocation from the ACC. Upon knowledge and belief, Clemson authorized this litigation against the ACC as early as 2023, so several months ago. Even when Clemson indicated the desire to work with the ACC through productive conversations, it was actually finalizing its lawsuit to file first in South Carolina. Anything you want to add there, Steve?
I would just say this is kind of like just watching the tables have turned. With Florida State, ACC, Florida State was mad that the ACC went and filed first, which was obviously a smart legal strategy for them. But now, basically the ACC is mad that Clemson basically did the same thing to them. While they were negotiating, supposedly in good faith, they were working on their lawsuit, and they got theirs filed in first, and now the ACC is mad. So they were happy in one side when they got theirs in first, but unhappy on the other side, and it's dirty tricks to do this behind our back and get it in first before we could file ours.
It is interesting that it kind of works that way. I would like to know what type of documentation maybe they have on this, if there's any. I mean, they state that they were drafting some sort of information or some sort of an agreement, assurances. These assurances were being documented. I'd like to know what that means. Because it could be interesting here, depending on what they have. And actually, that piece, I went over the 6 claims of relief early on, and the 6th claim regarding Clemson's obligation of good faith and fair dealing under the ACC Constitution, maybe comes into a little bit more play here, depending on what they have on these discussions between these two parties and actually having some sort of litigation because of that. I don't know, but it does go back to that 6th claim of relief.
I will say another thing interesting about this is that we talked about when Clemson filed, we talked about how Clemson really tried to be risk averse in their suit. They really tried to tread a little more lightly, keep it narrow, just not put themselves out there at risk, like Florida State just bashing through the front door, full frontal assault. Clemson really tried to be more targeted, less, they said, hey, we're not suing to get out. I don't believe that they put a date in there like Florida State had said, where if we get this relief, we're out backdated, to last August. They made clear in their suit they were not suing to get out, so that they were just that they wanted this, they wanted some kind of a ruling on this, the validity of this, before they went that far. So anyway, so they attempted to tread lightly to avoid some risk, and the ACC is clearly telling them, no, it doesn't matter. Nope. You were talking to us, and we thought we were going to work this out, and you went behind our backs. So you've already done it. You've pulled your finger out of the dam, whatever. It is what it is. So does this change Clemson's strategy going forward? Okay, well, they're going to accuse us of throwing the baby out with the bathwater. Then let's just go full bore. That'll be interesting.
It'll be. I agree. It's going to be really interesting to see what Clemson respond, or how Clemson responds to this, because this filing by the ACC very similar to what they filed against FSU.
Right.
They added this part about this trying to work together piece. Let's see what Clemson does. Does Clemson still try to ride above and stay with the 2 or 3 items that they just really want to find an answer to? Or are they going to be like, all right, you did it, now it's time for us to do it too? I don't know. We'll find out. It could get very salacious, as it did with FSU. The last thing I just want to point out is they did attach the grant of rights again here, as they did in the FSU filing. All members signed it, executed it. There was questions about who signed the FSU document, so I'm going to put that in this episode. The 2016 amended grant of rights was signed by Clemson University President James Clements on June 29th, 2016. Dr. Clements is still today the Clemson president. So he's still there, unlike FSU, who had presidents sign it who aren't there anymore, and actually 2 different presidents signed the grant of rights. This guy's still at Clemson, so maybe things are a little less messy because they've had ongoing leadership at Clemson. I don't know. I know I can tell you when you have a lot of high-level turnover, it makes for a lot of inefficiencies. So I'll just kind of put that out there, not for what it's worth. Anything you want to add, Steve, before we wrap this sucker up?
No, I think this is just kind of part 2. This is the refined part 2.
Yep.
And we'll just see the theater of war is widening.
Right. So our Clemson Tiger fan or ACC fan or just fans of figuring out what the heck's going on here in the college football universe, or just college athletic here for this, really. Make sure you give this one a like, subscribe, because we're going to stay on this till the very end. We're still following FSU. That kind of ebbs and flows. We kind of had a break there for a little while. Didn't have anything for a couple weeks, and now all of a sudden things have got crazy again. So we're going to add this to the list of updates. So, hey, with that, we thank you guys for watching. We'll see you next time on the Big Mountain.
I do declare that JY better say that word right, or the attorneys who watch our show are going to have his butt in court.